board minutes.
Cindy, the person with the comfort suites is not the one presenting, but just part of that, the Champ Boulevard one.
Okay.
You guys, go ahead. And then I think Kimberly's one of the neighbors.
Okay. You guys ready? Sure. Okay, at this time, we'll call the May meeting of the East Hempfield Township Zoning Hearing Board to order. Members of the board who are present this evening, Mr. Hanson, Mr. Luce, Mr. Kyle, Mr. Bingham, and myself, Elam Herr, I'm the chairman of the board. Also, we have with us our legal counsel, Jason Hess, our zoning officer, Nate Sturgis, and we have a court reporter present taking the minutes. We have 2 new cases this evening and any other old business that may need to come before us. This board will hear each case in an informal manner without strict compliance with the rules of procedure used in a court trial. We asked each applicant, any individuals interested in a particular case, to step up in front of the table and explain the circumstances involved in their application. Applicants may present their case themselves or through their attorneys or other representatives. Fellow board members and I, as well as our solicitor, may ask the applicant questions from time to time during the applicant's presentation or at its conclusion. All persons having an interest in the application will be given the opportunity to ask questions of the applicant, to offer evidence of their own, and inform the board of their position on the matter. In the interest of a prompt and orderly disposition of each case, we asked interested people to refrain from speaking until the applicant's presentation has been completed and the board has had the opportunity to question the applicant. At the beginning of each case, people who are interested in that case should decide whether they desire to be parties to it. By being given the status of a party, that person will be entitled to receive notice of the decision in that case and will be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions and present evidence, but will not receive notice of the decision and will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be a party, we will ask you to sign an entry of appearance form at the appropriate time. And although each party will receive a written copy of the decision, the mechanics of typing and signing the decision will take approximately 4 weeks. We ask that each person who asks a question or makes a statement first state his or her name and address for the court reporter. Now, lastly, in the interest of time, I will administer the oath or affirmation to all applicants and to everyone and anyone who anticipates making any statements with respect to any of the hearings this evening. So at this time, would you all rise, please? Under penalties of perjury, do you swear or affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth? If so, please say I do. Thank you. Stay standing. We'll salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Nate, the cases this evening were advertised in accordance with the Sunshine Law and the MPC.
Yes, sir.
Gentlemen, you have received the board's minutes of April 18th, 22. If there are no, submitted by the secretary, if there are no additions, deletions, or corrections, can I have a motion to approve the minutes as presented?
Mr. Chairman, I have one change.
Yes, sir.
Under minutes, it should probably read, Mr. Bingham made a motion to approve the March 21st, 2022 minutes with the following corrections.
Okay.
It was a great day, but we don't want to repeat the whole.
Anything else?
That was all. 2020.
Seeing that with that change, can I have a motion to approve the board minutes of April 22nd, 2022 as amended?
So moved.
Moved by Mr. Bingham, seconded by Mr. Luce. Discussion, gentlemen? Seeing none, Mr. Hanson,
In favor.
Mr. Luce,
In favor?
Mr. Kyle. In favor. Mr. Bingham,
In favor.
and I'll also vote in favor. No.
You don't want to think I don't believe you.
Thank you, gentlemen. Now, gentlemen, also, just for the record, before I forget it, which I normally do, not only do we have individuals present at the meeting this evening, we're also on Zoom. So anyone on Zoom, should you want to make any statements at the appropriate time, please let us know. Nate will be able to relay it to us. With that, any old business?
No, sir.
Okay, then, first case this evening.
Case number 2448, Joel and Catherine Fox for 2012 Marietta Avenue, requesting a variance to allow commercial use on a village residentially zoned property.
Is Mr. or Mrs. Fox here or their representative? And I should have said this, please come forward. If your attorney, you're going to represent them, if you would come forward and repeat that. I don't know if it's up to you. To respond, yes. Do you have a problem with her, somebody behind you? Yeah, then fine. You take either or.
My name is Victoria Stores and I'm an attorney. Is it not working?
You have to get pretty close to it.
I'm sorry. My name is Victoria Stores. I'm an attorney from Nicholas and Hohenadel, and I'll be representing Mr. and Mrs. Fox.
Okay. Before you proceed, is there anyone in the audience and or on Zoom that wants to be a party to this case? Anything, Nate?
No.
Seeing none, either in the audience or on Zoom, Store, would you like to present your case?
Yeah, so just to give a brief overview, the property is 2012 Marietta Avenue. There's a residential dwelling on the property as well as an accessory dwelling, and we're focused on the accessory dwelling today. It's previously been used as a commercial use, and the Foxes purchased the property and would like to continue that use. But there was a pause. That's why we're asking for a use variance. And then they come up here.
Please.
Okay.
Just so, again, everybody knows, the reason we ask that you come and speak into the microphones, a couple reasons. One is for Cheryl, the court reporter, make sure she can hear everything. Two, we do record this so that the board minutes can be copied. And three is so that individuals in the audience and on Zoom can hear what's going on. So please, everyone, speak into the mics.
Okay.
Thank you.
Please state your address.
Catherine Fox at 2012 Marietta Avenue, Lancaster, Pennsylvania, 17603.
And your name.
Catherine Fox,
Okay, thank you.
When did you purchase the property?
April 4th, 2022.
Okay, and what is located on the property?
It is our 2,200 square foot residence and the 1,600 square foot commercial building.
Okay, and how are you using the property right now? I'm sorry.
Right now, we are living in the house and our 2-year-old is enjoying some extra indoor play space.
So can you describe the accessory building?
It's a 1-floor building. It's 1,600. It's pretty, I think it's like 30 by 40. It's a pretty rectangular building, simple with 3 doors in and out.
I have pictures. I have some marked already for the court reporter, but I also have ones to pass out if that's okay.
Please. And please make sure Jason gets one.
The property.
Thank you.
Thank you.
You making this all one exhibit applicant
That's
number
one
one?
exhibit. Yes, this is just one. I have them paper clipped for the.
Okay.
Okay, and if you look at those pictures, that is the outside of the commercial property. The accessory building, I'm sorry. And then I have other exhibits as well of the property. I just have them separated, so I'm sorry.
That's fine, no problem.
Sorry, I'm losing my paper here.
No problem. Take your time.
This is what I'm bringing you now. It shows the inside of the property.
Want to shout and keep them together.
Yeah.
That is what's currently inside. As you can see, it has been utilized for commercial space in the past. Let me. Sitting here? Okay. So are you doing anything with the accessory building at this moment?
Not at this moment.
Do you know how it was used in the past?
The previous owners had run a carpet cleaning, carpet repair business, as well as miniature dollhouse furniture retail space. And that, I think she was working until December 2019.
Do you know what you would like to do with this accessory building?
We would like to go ahead and find a commercial tenant to be able to rent the space out and use that building.
Do you have any renovations proposed for the accessory dwelling unit?
Not at this point.
Okay, and do you have any other plans for inside that building?
Eventually, we would like to turn about 400 square foot into an in-law suite, just as our inside of our home doesn't necessarily assist for elderly living.
And I have a proposed layout of where the commercial portion as well as where the in-law suites would be if those were developed. It's over there somewhere. Looks like I'm missing one too. I'm sorry.
Ms. Store, before you go any further, your exhibits 1 were pictures of the outside, 3 of them, correct?
Yes,
Your exhibit 2, the inside picture 6,
yes,
and exhibit 3, 1.
yes, correct.
Okay,
I'm sorry.
just so I keep it up to date. Thank you.
Well, I'll just keep that. I don't know where I put my other one, so. Let's keep that one again. Have you spoken to any of your neighbors regarding what you plan to do with the property?
We have 3 direct neighbors, one on either side in our backyard with Lesser Lumber. And we have spoken with all of them that we are interested in pursuing the zoning to rent commercially.
And is the building as it is set up for a commercial use?
Yes,
Are there parking spaces provided?
there are 7 parking spaces. It's a macadam driveway.
Okay, and how would the individuals utilizing the retail space, how would they get on and off the property?
There is either access from Marietta Avenue or from Trolley Avenue through Church Street.
And do you know what kind of commercial tenant you're expecting to rent to at this point?
We would hope either like an office or some sort of retail antique, possibly space, more during like the banker hours, kind of 8 to 5.
Are you aware of any other commercial uses surrounding your neighborhood?
We have Lesser Lumber in our backyard. There are several hair salons. There is a funeral home, a few houses above, some doctor's offices as well.
And then with the accessory building the way it is now, do you think, being that it's a village residential property, it can be developed in strict conformity with being only residential? I was confusing. So the way the property is now, if you can't use that for a commercial space, is there anything you can do with that property?
No,
And do you think there'd be an increase of traffic that is unreasonable?
not more than already is seen on Marietta Avenue.
Will this use change the essential character of the neighborhood or its surroundings?
Very unlikely.
Will this use substantially or permanently impair any of the adjacent properties or their uses?
No,
Will this use be detrimental to the public welfare?
no,
Okay, and is this the minimum variance that would afford relief for you to operate the commercial building?
yes.
Okay, I think those are questions I have, but the board may have questions.
Gentlemen, questions, Mr. Hanson?
Say anything.
No, he doesn't.
We defer.
In your application, there are several hardships listed there, A, B, C, D, and E, F. The hardship A, you really don't answer the question. The question asks you, what are the physical circumstances or the conditions, including irregularity, narrowness, shallowness, and lot size or shape? And you're saying your answer is the property already contains the accessory building. That doesn't answer the question. What is the hardship?
Well, I have the application, so would you like me to refer to them the question?
You can, either one can answer it. It doesn't matter to me.
The hardship would be that there's this accessory building on their lot that they do not have any viable use for at this point. It was previously used as commercial, but now it's just an empty building on their lot.
They bought the property, didn't they not, knowing it was in a residential area?
Yes, they did. However, there are lots of other commercial uses along the Marietta Avenue, and they're just hoping to do what the previous tenants did.
This board in general does not view the property as a hardship if you bought it for one use and you want to use it for something else. The rental property you want to use as a little dwelling there, is that going to be rental or is that actually going to be in-law quarters?
At this point, it would be in-law quarters or guest quarters for friends who are out of state.
So basically what you're asking, you're going to use it as a guest house. So now you want us to put 3 uses on a residential property,
Well,
residential dwelling, a guest house, and a commercial property.
The guest, so the in-law suites would be in the same building but yes, it would be that the accessory dwelling unit is something that, from our understanding, we would just need to ask for and get a permit for. So what we're asking for today is for the mixed use with the commercial building on the lot.
You do realize that the only mixed use in the township is in the CBC zone or the commercial zone, correct? And this is a village residential zone. By allowing a mixed use facility in a residential zone, you are changing the character of the neighborhood.
Okay.
Would you agree with that?
I don't have a comment on that.
You want to interrupt?
Can I interrupt? you
Sure.
for a sec? The statement was made that the previous owner had the commercial business. Do you know when that business ended?
According to the daughter, I believe it was December 2019, which then there had been a lapse of her special permit that she had applied for.
Uh,
I believe this case was involved in another zoning issue.
yeah, I don't, if it is, it's not marked here. One second. Nate, do you know?
I could not find anything when I searched for it.
Okay, so that answers that. Okay, I interrupted you.
So just because this was used as commercial property, it could have been used as commercial property long before the zoning ever went into effect in the township. So at this point, as far as I know, this area has always been, at least my 17 years on the board and 3 zoning ordinances, this has always been a village type residential area. It has never been a commercial area. If zoning has changed, you can continue to use the uses as grandfather. Because it's been more than a year since it was used as a commercial facility, that's why you need to be here for a variance. So I still really haven't had an answer of how this does not impact the neighborhood by putting a commercial use in a residential use.
Well, there are already commercial uses in the neighborhood along the road. I believe the lumber yard is in the back. We are anticipating that by adding the small business, it's the same as what a lot of the other properties are doing.
I can tell you some of the properties here have been before the zoning board and gotten variances or whatever. The 7 spaces that you're saying are there, do they currently meet the township requirements for parking spaces for commercial facility? And I guess that'd be a better question for you.
I have not reviewed it for that.
Are they striped?
I do not know the answer to that.
They are not.
So they currently don't meet township requirements for a commercial facility. So you'd have to bring it up to commercial standards.
We definitely could handle that.
Okay.
Yes, of course, if there are any permits that would be needed, et cetera, that would be dealt with.
Thank you.
So, any other questions?
Can I ask one?
Oh,
just,
Mr. Bingham.
To make sure I understand this, there's a white brick building and a red brick building. The white brick is the existing commercial use. The red brick one.
Excuse me 1 second. Can you just state your name and that just for the record, please?
Joel Fox, 2012 Marietta Ave, Lancashire 17603.
Thank you, sir.
Yeah, it appears to have been probably a carriage house in 1911
Quite possibly.
with that upper door for hay. Okay, thank you.
Mr. Lewis.
So at this time, you're only asking for the accessory, not accessory living quarters. You're just asking for commercial use.
That is correct.
Okay.
Wait.
You're going to change your application because your application is asking for all 3.
Yeah,
when we did originally do that, and then I actually spoke to Nate and we were informed that you no longer needed the permit. I mean, you needed a permit for accessory dwelling. So we were trying to do all three when we thought that you needed a special exception for it. So
My understanding of the zoning ordinance is you do not need a permit for an accessory dwelling unit, which would be an in-law quarters.
yes,
If you're going to use it as a guest house,
or
that's a
rental.
different story, or a rental, that's a different story.
no, it was intended there, if they are using it, it's intended to be used as in-law quarters. When we first put the application in, we thought that we needed to request relief for the, excuse me, in-law quarters. So the original application did say that, but then we resubmitted after I spoke to Nate, and we were just asking for the use variance.
Well, then there's some other potential modifications to your application that I'm going to get to when we're done before we conclude testimony. I think we should also address that to take out the request,
We turned in a new narrative and everything.
the narrative, but not only, I'm not sure, is there a new application form?
I believe in the packet that I submitted to you, they included the updated application.
I did not see that.
I'm not, Mr. Chairman, I'm not, it looks like they're asking for the mixed use, because I think if they want to have a commercial use in the same structure as a residential use, even if they're not renting it out, that it would have to be considered a mixed use. Is that right, Nate? I mean, if you're combining a commercial building in the same structure as, even if it's just your guest room, I think it would be considered a mixed use.
Mixed use, but unless they're asking for the living quarters in the accessory building is just for a in-law quarters, lack of a better word right now in this discussion. I don't think that needs to be in this application. And I haven't seen the modified one, and I need to look at that one quick. Because the first one that I saw said mixed use, commercial and residential under sections, and those sections have to be modified too, and I'll check that out.
I just double checked. One in the packet is the updated application.
Does the updated one have the number on it? Let me see yours.
The one we had no case number.
Yeah, it had no
Right.
case number, which we
That's the
have.
updated one.
That is the updated one. So that's where I'm coming down at. And we don't need to discuss it now. We can discuss it when I bring up the other issues when we get to that point. So, okay. I think Mr. Hanson asked this question. When you bought the property as your residence, did you know that the commercial activity in the accessory building was no longer being conducted?
We knew that the owner had not lived there since October, but we were not entirely sure of when her
Okay.
business ceased.
And I'll ask you this question. If you have the answer, fine. If not, fine. Did the real estate agent in any way indicate that the property you were buying could be used for both residential and commercial?
This was bought at an auction.
Oh, okay.
So there was that. This has been used in the past, just confirm.
Okay, I appreciate that. Thank you. What, Mr. Hanson?
So you're actually, at this point, only want to have two uses on the property, is that correct?
Including the residential, it would be the residential use in the primary building, and then yes, it would be a commercial use in the accessory building, which we did ask for mixed use because, as was mentioned, if in-law quarters go into that, it would be a mixed use building.
I can't speak for the rest of the board, but in my opinion, you need mixed use just because you're going to have two different uses in a residential zoned area. But if you do
It's the
turn that
same as
into
that.
a guest cottage for guests, to me, that now becomes 3 uses. And again, I can't speak for the rest of the board, but to me, that becomes 3 uses on one property. Accessory dwelling, I understand is allowed. That's not an issue. But if you use it as a guest house, it's no longer meets the definition of an accessory dwelling.
I understand. At this point, we are not asking for accessory dwelling. We are asking for commercial use on the property, on the village residential property. And we did ask for mixed use of the building if in the future it were to be used as such. So the mixed use was for a mixed use building. We were asked for the accessory building to be a mixed use building that has more than one use in
I
it.
understand it. In my opinion, you still need the variance because the property is a mixed use property now. You have a commercial business there, you have a residential. That's 2 uses. You're having a mixed use on the same property that's zoned residential.
Yes, I understand that.
Yeah, I think that's understood. It's the
Building.
the
How it's worded right on here, it says is requesting a variance to allow the accessory building to be mixed use, commercial and residential.
right.
So the accessory building is being asked on this application to be used for both commercial and residential. That's where the confusion is setting in.
Yeah, right.
Yeah,
You're right.
and if I may explain that, that would be because there are thoughts in the future that they may use that as in-law quarters. There in that I provided, it looked sort of like this. It showed the garage and then the commercial space as well as what would be out for the accessory dwelling for the in-laws quarters. That there are no in-laws quarters at this point. This is what they are hoping to do with the property, but we were first seeing if they can do commercial on, and then, yes, if that, just the accessory building, if they did that, it would be mixed use. A mixed use building.
Mhm. Any other questions, gentlemen? Jason?
Give me 1 second. So if you got the approval at this point, the portion of that building that is anticipated for residential, you might allow guests to your house to stay there if you have visitors or something.
At this point, it would be very rough for them, but in the future, yes, just to stay there. Our family's all hour to 2 hours away. So, yes.
Can I ask a question?
Okay, sure, you want to follow that up?
Yes, I'm sorry. Is it the accessory building and the portion, is it set up at all at this point for anyone to live in it or anything like that?
There's a toilet and that's it.
Yeah, so at this point, no one's going to be living in that portion of the property, is that, or staying in it? Is that correct?
Correct.
Yes. Thank you.
Okay, and you won't know if any renovations would be needed until you would actually find somebody, a commercial tenant to, okay,
Correct. I mean, we do have electricity is on a separate meter. And there is, I think, oil heat out there. But that's the gist of what we know.
okay. I'm a little, just wanting some clarification on this A3, because you show commercial 30 feet by 40 feet. And then I guess the garage is 30 feet by 20 feet.
Yeah.
Okay. But then there's it says 64 down there. I'm not sure what that means. Is that I'm not quite sure that the total dimensions of this other part. I know it's 30 feet wide.
Sure.
But-
64 would be, I apologize.
Yeah.
This to this, the whole length.
Oh, so it's 50 plus.
So it,
There's a carport where the L is. Oh, well, it says existing carport.
This is a different one, but it shows the whole, that 60, this is before it's broken out for the accessory dwelling.
Okay.
so we would be taking, it would be the 40, 64 minus 40. 24 would be left down in the little,
24. Okay, I see.
the L7.
Okay, gotcha.
Jason, if I'm looking at that A3, where the wording says commercial 30 by 40. I presume, and correct me if I'm wrong, looking at it from Church Street, 20 feet, which is, north and south, says garage, personal use, something, it's blurry, property owner. That's 20 feet. Then where it says commercial 30 times 40 has 50. Plus, I presume that is from where the property owner, what I just personal use for the property owner stops, and it goes down to where it says existing carport is 50. Because if you look right next to existing carport, it says 14.
Right, yeah.
Following me?
That makes sense.
So I presume, although it's divided into 3 there, the way those numbers are, it doesn't add up unless you say that one side is that full 50. And I guess it's west on Marietta Avenue would be this 64 square feet.
Right. Yep, that makes total sense.
Okay.
Okay, I don't think I have anything further.
Nothing further?
No.
Jason, do you have any questions? Oh, Jason, Nate. No wonder you're looking at me weird, like. And, okay, is there anyone in the audience and or on Zoom that have questions for the applicant? Anything, Nate, on Zoom?
No, sir.
Okay, seeing none. Okay, anything else, Ms. Storrs, that you want to add at this time?
No, thank you.
Okay, any other questions? Oh, no, for that. Anyone in the audience or on Zoom want to make any comments, either pro or con, to this application? Seeing none. Anything else, gentlemen, before we conclude testimony? Seeing none. Ms. Storrs, first with you to go. On the appeal, there was no number, so we got to add the number to the appeal of 2448.
The appeal?
Well, it's appeal or case number.
Oh, okay.
It's listed on these sheets as appeal, which
Okay.
is a case number. Second thing is in the application down under nature request, it said sections 270, 37B. I presume what you're saying is it's request is for 270-3.7B3 business uses, or
I apologize if things, when we did the second application, if something was incorrect, yes, subsection 3.
okay. And then back on section 279.13. I think you are saying there, is it, the 3 is under A or D? I'm not sure which one you're asking
I-
for. Do you need a copy of the ordinance?
Yeah, I only have this.
Okay, no problem. You have 279.1, and then you say 3. So I don't know if it's that 3 under A or D. I think it's D down there. 3. See, there's D. 3. I didn't to me either, so
I think I know what you're referring to. It would be 2.7-9.1 E, which is ZHB's functions, and then E subsection 3, which is variances.
Okay.
So it should be 270-9.1 E3.
okay, that's no problem. Okay,
Would you agree with that? That's what you were, okay.
Missing the E.
okay. Since literally none of these proposed changes really affects what we were here tonight. So gentlemen, and you agree with the 3 changes that we discussed?
That being the,
The case number and the 2 section change.
yes.
Okay, gentlemen, we have a request of the applicant to amend the application for 3 things. One is to include the case number, which is 2448. We also have the request to reference the section 270-3.7.B3 and section 270-9.1E3. Can I have that as a motion, please?
So moved.
Moved by Mr. Hanson,
Second.
second by Mr. Bingham. Any questions, gentlemen? Seeing none, Mr. Hanson,
In favor.
Mr. Luce,
In favor?
Mr. Cobb,
In favor.
Mr. Bingham,
In favor.
and I also vote in favor. Your application has been amended as stated. Now, with that, gentlemen, I have no administrative notice to be made part of the record. We will admit into evidence applicants' exhibits 1, consisting of 3 pictures, applicants' exhibit 2, which consisted of 6 pictures, and applicants' exhibit 3, which consisted of 1 diagram. With that, there is no other administrative action. So at this time, gentlemen, we have concluded testimony in case number 2448. And I will listen to a motion if there is one.
Mr. Chairman, case number 2448, requested Joel and Catherine Fox for property located at 2012 Marietta Avenue, Lancaster, PA, 17603. I make a motion to deny their request based on lack of a hardship, or proving their lack of a hardship, or proving their hardship, I'm sorry.
Deny the variance request.
Yes.
Okay, I have a motion by Mr. Hanson in case number 2448. Request of Joel and Catherine Fox, property located 2012 Marietta Avenue, Lancaster, PA 17603, to deny the variance request due to lack of, what'd you say?
Proving a hardship.
A lack of proving a hardship. Motion, do I have a second?
Second.
Seconded by Mr. Kyle. Discussion, gentlemen?
Yes.
Mr. Hanson?
The reason for this is if you look at their application under the description of hardships, A, B, C, D, and E, they really don't answer the questions. Number two, you're buying the property. Okay, you bought a residential property. Yes, there was a commercial building on there. It was used as commercial. That use had expired. I just don't think, from what you've presented tonight, I don't see a hardship here. You haven't made your case for a hardship, so that's why I made the motion the way it is.
Thank you. Anything else, gentlemen? Okay, seeing none. Mr. Hanson, how do you vote?
In favor.
Mr. Luce? Opposed. Mr. Kyle? In favor. Mr. Bingham?
In favor, but I would hope that the applicant will reapply, providing a description, the answers to the questions that would give you the basis to make the request that Mr. Hanson outlined.
So in favor.
In favor.
And I also vote in favor. Your request for a variance in case number, I lost it, 2448 has been denied. Thank you.
For your time.
Cheryl, you okay? Okay, Nate, next case, please.
Case 2373, the Champ Group, 543 Champ Boulevard, seeking a modification of conditions to their special exception approval.
Okay, before we no, there's a technical just issue which really doesn't change the application. I just need to think how I'm going to place this. The due to the circumstances of this case, let's first get people listed. So we'll go from there and then I will do some administrative work. Is somebody representing Spooky Champ Properties present?
We're present on behalf of the Champ Group.
And we are who?
I'm the attorney, Riley Notzel with Barley Snyder.
Good, you're the guy I want to talk to then.
Can you say your name again, please?
Riley Notzel with Barley Snyder.
Okay. Anyone in the audience or on Zoom that wants to be a party of this case? Willing to sign the form? Come forward. How do you spell your last name?
Noetzel.
Notel?
Notzel, yes.
Notzel. I might mess it up one or two times during the whole thing. Nate.
Her name, her address.
Nate, anyone on Zoom that wants to be a party?
Yes, Kimberly, I'm getting her information now.
Okay.
While they're doing that, one of the representatives for the applicant actually tested positive for COVID. Jacques Abreu, he's the assistant general manager of the property. He was actually on Zoom and we were hoping he could actively participate. I had a few questions for him. He's since signed off because he's not feeling well, but in the event that he does come on, is that acceptable?
Yeah, well, anybody that's on Zoom has the ability He's already a
Yeah.
party to the case since he's with Champ Properties, so that's not an issue there.
Okay.
That's okay.
Kimberly Swartz, 2543 Shank Road. She is a neighbor or neighboring property.
What was the address to?
Say again,
What was the address?
2543 Shank Road.
What's your last name?
Swartz, Swartz.
And is her property adjoining?
It's not adjoining, but it's near.
Like, I mean, how close?
Jason, the Shank Road is, if you're coming from 283 north, it's the first road that you would turn left. It's in the middle of the Nook property to the east. Their property would not necessarily border, but it is in the neighborhood.
And just for reference, Dr. Zarco was a party of the original case.
Are we okay?
So, yeah, we should ask Attorney Netzel if he has any
Right.
objection to either of the parties.
No, no objection.
Either one?
No.
Okay. Mr. Notzel, in your application that you filed, to get some modifications to the previous case. Talking with our solicitor and previous knowledge, probably should not probably, it should not be, this case should not be listed as 2373. It should be a new case. So to follow the normal numerical notations, this case would be listed as 2449. And the case 2373 will be made part of the record. In which case then any of the parties could, if they have any concerns, issues, and they would file an appeal with the Court of Common Pleas, they would be filing the appeal to this hearing and not the previous one. You understand that and you're agree to the case number change.
Yep, agreed. Thank you.
Okay. Thank you. With that, would you like to state your name, address, and present?
Mr.
Oops.
Chairman, before we do that, I think that we should have the application in 2373 and the decision in 2373 marked zoning hearing board exhibits. And I have them ready here. Yeah. Just.
I feel your pain.
The conveyor belt going across here, you just put it down.
Thanks. Okay, before we proceed, just so the record is clear, and Cheryl, did he give you copies? I'll give you these, but applicants or zoning hearing board exhibit number 1 will be the application that was filed in 2373. And that is 16 pages. East Hempfield Township Exhibit number 2 is the decision of the East Hempfield Township Zoning Hearing Board in case number 2373, and there are 11 pages to that.
Township or the zoning board exhibits?
Zoning Hearing Board.
You said township.
Did I? I can't read his initials or letters. They will be made part of the record at the appropriate time also. So, okay, with that now, I think we got all the administrative out. So would you like to state your name, address, and present your case?
Sure. My name is Riley Notzel. I'm an attorney at Barley Snyder, 126 East King Street, Lancaster, PA 17602. I have with me Patty Brewer. She's the wedding and events coordinator for the Champ Group. And I also have Steve Gergley with Harbor Engineering. Both of them will give their name, address, and further information when they come up to testify. The property in question is 543 Champ Boulevard. It's sort of near the Spooky Nook and the interchange, 283 interchange. Currently there's a hotel operated as a Comfort Inn and suites, a parking area, and a lodging facility that's used for guests of the hotel. And as you may know, it's also rented out for wedding events. The reason we're here this evening is not to change, the use of the property is not changing. We're just seeking a modification to the original decision that was granted back in 2017 under case number 2373. Under, excuse me, under that case, the zoning hearing board granted a special exception for use not provided for to allow weddings and special events on the property. But one of the conditions to the decision was that they would be operated in tents. And due to changes that have happened over a number of years, especially related to COVID-19 and some other demands in the wedding industry, the applicant would like to have the option to construct permanent pavilions in lieu of tents on the property for the same purposes as was provided for in the original decision. So just to go into a little bit more detail about what the decision referred to and some of the modifications that we would like to make. The decision references obviously the use of temporary tents for weddings and receptions. And as part of our application, we submitted concept plans of what a pavilion might look like on the property. And Patty will speak more to the reasons why a pavilion is more desirable in this current environment. The use of the pavilions would not be any different from the tent. So as part of the original decision, tent 1 was to be used for dinners and special events. The pavilion that would be placed there would still be used for dinners and special events as well. So that wouldn't change. The only modification or clarification, I should say, really, is that the applicant would also host ceremonies in that pavilion once constructed. It's actually farther away from the outdoor area of where the ceremonies are currently held. And the applicant feels that that would give wedding brides and grooms the opportunity to use an indoor space in addition to maybe an outdoor space. So just to have that additional flexibility. And then tent 2 was the tent closer to 283. And we'll go over that in more detail on the plan. That was under the decision to be used for receptions and dancing. That use of that area would still remain. And I should mention that the pavilions wouldn't all be constructed at the same time. So one may be constructed before the other, and in the interim, the tent may still be used for that use. So again, we're just looking for more flexibility to not only have to conduct these uses in tents.
Excuse me,
Mr.
Nate,
Hanson.
can you blow that up, especially the venue section?
And we will be going into more detail about the plan as well. So hopefully we can answer some of your questions then.
Just to ask a quick question here. You did say that tent 1 is used for the weddings, correct?
Yes, it's primarily used for the dinner aspect of the reception.
Where are the weddings actually held?
Well, they're held outdoors when possible. And I think Patty can speak a little bit more to that if you want to come up.
Hi, my name is Patty Brewer. I am on 107 Bruceton Drive in Leaditz, PA, and I am the venue director for Chestnut Hill Villa.
So
So
can you,
you're asking where the ceremony is held. Ceremony, if you can see where the dining tent is there, to the right of the dining tent, we set up white guest chairs with an arch, and that's normally where the
I'm
ceremony
going to
is.
give you a,
Sorry.
maybe, going to give you a pointer,
Okay.
but you're going to turn around.
You're
and
gonna turn
point
around
to
and point
that one. Because if you point to the one you were looking at, we'll never know what you're talking about.
But you have to still speak into the mic.
How do I get this to go? Oh,
There
here
you
we
go.
Everybody can hear me okay? I don't usually need a mic. So this area right here is where the ceremonies are normally held if it's an outdoor ceremony. If it's an indoor ceremony, we bring it over here to this tent here, which is our celebration tent.
The
If it
one-
rains.
That's the barn you were pointing at. You mean just to the right of the barn there?
I'm sorry, sir. Yes, sir, right
Right
here.
there,
Yeah,
okay.
we would set that up for their ceremony area if it would rain that day. Otherwise, it would be outside to the right of the dining tent.
Was that in your original application, 2373? I don't remember anything about the ceremonies being held outside. I always thought they were going to be held in 10-1.
that's why we mentioned this, because we think it's more of a point of clarification. I don't know that the decision actually references where ceremonies will be held. Obviously, with a wedding, there's going to be a ceremony, so we wanted to clarify that they may be in the location of Tent 1 or Pavilion 1.
Is there any outdoor speakers or anything used during the wedding ceremony?
So Patty may be able to provide a little more info, but I will say that, yes, there would be, traditional ceremony music, but and Patty, would that music be any louder than what would be provided in a dining setting?
No, sir. Usually the ceremony music, it's usually when the bride's walking down the aisle is when they play the music. It's a softer, more of a dinner music that they play, as well as the same for when they're dining in the tent.
One of the just lost my train of thought. Come back to me.
It's,
Oh, I know what it was.
no,
I'm sorry.
is it relevant now or can we hold it till?
Oh, yeah, it has to do with the reason I'm asking about the outdoor speakers is because one of the concerns that was expressed by the board was the noise leaving the property. Has there been any complaints? And I'll ask this question of both you and the township. Has there been any noise complaints since this has been in operation?
Patty, can you answer that?
Since I have been on with them, I have not had any complaints of noise.
Nate?
I have not received any that I'm aware of.
Okay, thank you.
I don't want to interrupt the train of questioning, but if I could continue.
Yeah, please.
And feel free to interrupt if you have another question. But that was actually one of the points that we wanted to make is, these requested modifications, the noise level is not, we're not saying it's going to be any different than what was originally approved. It's just more so where these may take place and kind of giving the flexibility to have these events operated out of pavilions instead of tents. The only other modification that we'd be requesting has to do with the length of the wedding season. So in the original decision, it was that they had to be held May 1 through October 15th. Due to changes in the industry, we're seeing more brides and grooms request weddings in colder months. So the applicant is seeking to have weddings during the April 1st to November 30th timeframe to provide a little bit more time to offer weddings to their guests. There's also, as Steve will mention, some additional patio areas that would be constructed as part of these changes. And obviously the applicant would go through the land development or get a waiver of that process after assuming an approval of these modifications takes place. And finally, we also wanted to clarify as part of the decision, the intent would be for these pavilions to be used during the off-season by guests of the hotel for meetings. One of the things you're seeing more with COVID is guests kind of wanting to have different flexibility of where they host meetings. And so during the off season, when weddings aren't really an option for the applicant, they want to be able to have these pavilions used for guests to have, lunch meetings or things of that nature, not really involving any music or large events, but more so just ancillary meeting uses when maybe a conference room is full at the hotel. Again, the primary users of this property are either guests or during the wedding season, brides and grooms. So I guess the only other point I would make is the parking is the same as well. No changes there. And obviously the sound is not going to change. There's not going to be any proposed amplifiers or changes in noise. And the capacity is going to remain the same even with these pavilions. The testimony as part of the earlier decision was that there would be 199 guests for any one event, and that's still remaining the same. So I guess, Patty, you've already introduced yourself, but I do have a few questions for you. Can you just tell the board a little bit about the impacts you've seen over the last couple of years, especially with COVID in the wedding industry?
Absolutely. Our couples are definitely looking for a lot more flexibility. A lot of people went from indoor facilities to outdoor facilities. They love the room that their guests can move around inside and outside.
Have you seen an increased demand for weddings during different times of the year?
Absolutely. Since COVID came about, couples are actually looking more for the colder months instead of the summer months. So we do get a lot of requests for a little bit of a colder weather wedding.
When you mentioned flexibility, is there a desire also for more amenities to be offered? And can you explain a little bit of why the pavilions make sense right now for you?
Absolutely. So the pavilions, number one, it would be our pavilion, so they would be able to decorate it the way that they want. We rent our tents right now. Also, our couples are liking the flexibility of not having or being forced to use the look of the tent and have more of a structure feeling to it, wooden frame type thing.
Yeah, it sounds like they'll give a little bit more of customization. Would the use of the pavilion one, which is the pavilion sort of more interior to the property, be different from the use of the tent that's there?
Yes, yep. Pavilion one would be mostly our dining pavilion.
And that would be the same as the tent that's there, right?
Yes, sir. Yep.
Okay.
Doing the same exact thing that we're doing now.
And similar question, would Pavilion 2, which is closer to Route 283, be used for the same thing as the tent that's there, which would
Yes.
be dancing and receptions, right?
Yep, that would be our louder music area.
Thank you. And then I don't know if Jacques is on. It does look like he is.
Can I, before you move on?
Sure.
Yeah.
So
We're going to questions for the witness and then.
Perfect.
you can go
That's
on to the
great.
next
Yep.
one. Mr. Hanson.
Ms. Brewer, it was mentioned in the application that you may enclose the sides. And I can understand that for later on weddings. But you also just mentioned you want to use this year round. That's not what the original decision was based on. The original decision was based on this being a wedding venue, event type thing, not to be used by the hotel for other meetings.
I understand your position. The way we read the decision and based on our prior experience from the presentation, it was a use not provided for weddings and special events. And
Right.
I know the testimony was surrounding sort of the use for weddings on a seasonal basis.
Matter of fact, I think the question was even asked, because I asked it, did the hotel plan to use anything else? And the answer was no.
Yeah, and we recognize that that was probably the discussion back then, but due to changes, as you can probably imagine, over the past couple of years, we figured we would ask for that modification just to, again, go provide for more flexibility. It seems to be sort of an ancillary use to the hotel, which is already permitted there. So if there's no music and there's no sort of, noise associated with it, that would only be with the weddings that occurred during the wedding season. It seems to me that that would be just a related use to the hotel anyway.
So you're asking to go to the end of November, correct?
That's the request, yes.
So I can tell you, last November 2nd, I think we went below freezing. How are you going to keep guests warm if you go below freezing for an outdoor event?
I will defer to Patty on maybe some of the things you offer for colder wedding months.
Yes, absolutely. We do allow the guests, they can bring in heaters. The heaters are actually outside of the tent or the structure, but they would blow heat inside to keep it warm for them.
Are they generator run?
I honestly am not real sure, sir. We actually don't get a lot of rentals for heaters at this time. We would probably recommend that they would rent them through Hess Tent Rental. And I want to say that they may be propane. I'm not sure that they're generator.
Okay, you said something, and if you did enclose these,
Yes.
the only reason I can think that you would be enclosing this is to make this year-round use, which is definitely, it was not in the original decision.
I can't speak for maybe what Patty has to say. I'll say from a legal perspective, we did submit concept plans. These are all conceptual. They've sort of been in discussions about what these pavilions could look like. And actually, understanding your point about enclosing it for year-round use, I think another more primary factor is actually the fact that it looks really nice with the glass. And some of the pavilions that they've been exploring actually allow the panels to be removed and put back on. So again, it would give the flexibility for a bride and groom to, take it off if they're going for more of an open air look or enclose it. The tents were open. So having this flexibility can give brides and grooms more amenities.
The two pavilions that you want to build, would they match the footprint of the existing tents, or would they actually, number one, be a little bigger?
I think Steve may be able to speak to this, but I believe the only additional impervious area that's being proposed would have to do with the patios and walkways. These would be additional impervious, but they would be on the footprint of where the tents are.
Okay, thank you.
To follow up on that, I can say it from here. If the pavilions are, and the conceptual drawings that were submitted with the application, the pavilions look very permanent. In the application, it talks about them being like temporary. I cannot, as the same as the tents, I can see the tents being taken down. I cannot see these pavilions being taken down.
I apologize if there was any confusion, but the intent is for those to be permanent.
Okay, that's one. Two, what is the benefit of the pavilions in inclement weather, whether it's expanded to a colder season, but rains like we had last evening, if that was during a wedding, if the pavilions that, again, the conceptual look without glass or anything else, and I presume it would be glass to give that open air look. What good is that if you cannot prevent the weather from coming in? I mean, tents, you can roll down the sides pretty fast. I don't think you can put glass panels in relatively fast.
I'll let Patty elaborate, but I would say probably you're planning a couple days in advance for the weather, correct?
Yeah, I'm a weather watcher for sure. Our couples have to make a decision about the weather on usually Friday. They come and they check in with us on Fridays. They usually get married Saturdays. And I try to get their plan all ready to go on Friday. So we would have those panels in and ready to go. Also, we wouldn't do weddings in the winter time, like more December, January, February months, because we are an outdoor venue and our guests are walking down. So
Understand.
It would be more for meetings in the winter months.
I understand, but even till November, it can get very windy. And rain, I'm not even talking about snow, which we can get. And, the weather is very unpredictable. Yesterday's weather was not totally called for the way it ended up. And I just have a concern if you're building these pavilions, whether it's July or it's September, I presume why you're going to the pavilion beside looking better than a tent is for the ability to have the type of structure that you could have this at least 9 months out of the year.
I would argue too that the pavilions are more durable than a tent. To your point, yes, maybe a tent, the sides can roll down quicker, but the pavilions are, as I mentioned, going to be permanent. So hopefully it would withstand some of those strong winds and snowstorms if they happen in November. or April.
Well, I can see them standing, but I mean, I've been in pavilions where when it starts raining and blowing, doesn't matter how close you get to the center of it, you're getting wet. That's what I'm talking about. And I can't see a bride wanting to be standing, sitting in a pavilion, looking like she's a drenched cat.
Yeah, I can understand that. And Patty, I mean, I think that's why you guys are looking at these removable panels, right? To be able to offer it, enclosed areas.
No, just for Mr. Hanson brought up, and it's an issue that I have, is that, and again, maybe your architect or whatever better answer these questions, but again, you're proposing the pavilions basically on the same footprint of where the tents presently are. The footprint may not be necessarily the same because it's the way tents are in that, but it's in that location, correct? Both of those. The second thing is, and the question with that is, during the construction of these pavilions, I presume you still want to have a tent up.
We would do the construction off season. So this pavilion would be built when we are not scheduled to have weddings.
Okay. So literally, you would not need a temporary site for the tent during construction of the pavilions.
No, sir.
Okay.
No weddings during construction.
Okay. Now, again, I don't know if, Ms. Bauer, if you're the one to answer this question or not, but in the application, it keeps referring to the area close to the Route 283, where tent 2 is. Now, what is that area? Under the original application, there was only 2 spaces beside the barn itself that were to have tents, pavilion or tent 1 and tent 2. Tent 2 was closer to 283 and in the vicinity of the barn. What is the area?
What do we use it for, sir?
It's in the application, it says proposed area.
We're referencing more so the location. So the way it's referred to in the decision is the tent 1 and tent 2. So to refer to that for consistency, we're just saying in the same location as tent 2 will be the pavilion.
Understand, but you also have the area closer to 283. There's a lot of area over there closer to 283 that is not does not specifically address the area of the tent.
So do you mind referring me to where that's mentioned? I can probably clarify.
Well, one place that's right in front, your proposed condition number 16 says the area closer to 283, where tent 2 is presently located. Why doesn't that say the pavilion closer to 283, where tent 2 is presently located?
I think the intent was to refer to location. There are going to be patio areas that are proposed as part of this that the applicant will be getting approval for. So I guess the point was that the patio areas would also have people out on them as part of the receptions. Not so much music there, but I'm sure there may be tables set up there.
Because again, on page 4, it says at one point, it says applicant may use the tent it is replacing for weddings and special events, or in the case of the pavilion proposed closer to Route 283, Pavilion 2, the outdoor area patio may be used for weddings and special events. That was never part of the decision in the first case. And again, I think it needs to be spelled out if you're expanding the use.
I would just say that, yes, it's not in the original decision, and that's why we're asking for a modification, because there are patio expansions being proposed. So
But really, is that a modification or is that a new request?
well, the use isn't changing.
No, but the location is. The use that was requested for in the original case said that there would be tent 1 and tent 2. Both were presented with specific locations. Now you're saying you would like to substitute pavilions for tents, whether that's good, bad, or indifferent. But you're also now saying we want to use additional areas beyond the footprint of tent 1 and tent 2 for weddings and special events. To me, that's not a modification of the last decision. That is a new request for an additional activity, because it's the same use, weddings, special events, but it is being expanded. Rightfully or wrongfully, whether it's good or bad, I think it needs to be spelled out.
I would argue that it doesn't need to be a new request because, I mean, the use is staying the same. So we would just be modifying the decision to reflect where the use is occurring. Steve can probably speak more to this, but the patio areas aren't intended to be used for encompassing these events. They're just being constructed to offer, again, more amenities to guests. So we just wanted to make it clear that it's not just occurring in tents anymore. We would ask to have these pavilions up. And there may be guests who go out onto the patio, which seems to be a reasonable use associated with a wedding.
I might agree with you on the latter part being a reasonable use in conjunction with the proposed pavilion number 2. But again, I think it's an expansion of what was requested the first time, not a modification. The first time you said, and this isn't the exact numbers, we want a 20 by 30 area for a tent. Now you're saying we want to use that 20 by 30 area for a pavilion. That's the modification. Nowhere previously did you say that besides that 20 by 30, we also wanted to have a area 10 by 20, works out the same way, for an area, a patio, whatever, for the guest. To me, that's not a modification. The modification is tent to pavilion. Nothing to something doesn't seem to be the same.
And respectfully, what would be the purpose? Why is a condition modification an option to apply for? Like, I guess my question is, if the use is staying the same and it's only a condition, the only things that we're modifying are the conditions where the use is conducted, which were spelled out as being tents. So I guess I ask why the township provides the opportunity to modify conditions if it's specified to you're only allowed to replace something with something else.
Because the applicant asked for a specific relief originally. Now they're asking for a relief to a relief. Now, under what you just said, in my opinion, is we can ask for the whole area, the whole property, to be part of these 2 pavilions. I see that as going beyond just the modification. And I might not have any problem with the patio for what it is, but I just don't think that granting the modification from tent, which is what the applicant originally asked for, they asked, we granted, to now say, we want a pavilion and all this other stuff. To me, the other stuff is not and needs to be explained where it's going to go and why it's needed.
And I agree. I mean, I think changing the whole use to allow weddings all over the property would not be, but I guess I would say that the decision itself isn't specific. It just says, tent 1 and tent 2. It doesn't even go into square footage of the tents. So I would make the argument that, these additional minor patio areas, which are ancillary to where the tents are, it may fall within that.
The decision does not go into the square footage, but the decision was based on the submittal and the testimony. And the submittal and the testimony spelled out where they wanted the tents and basically the size of the tents. Now, literally, somebody coming in here that's not with a tent company may say that, the tent itself is 20 by 30, but the footprint is 25 by 35 because you have the stakes and everything else. So you and I could stay here all night and argue, and I can guarantee you won't get the last word in with me, but that's beside the point. And Cheryl is smiling because she's heard that statement before. I just feel that if you want additional requests, you need to explain where they're at, why they're needed.
No,
That's all.
and I appreciate that. And I guess I would ask Patty, I mean, can you speak to more as to the patio areas?
Yeah, you and I should have had this conversation 20 minutes ago
Yeah.
instead of that way, but.
I'm actually there for every single wedding, so I know exactly how everything runs. So the second tent, what we are looking for is to just replace the tents with the structures. Now, the patio, the proposed patio expansion that you see was something in the process of thoughts, not something we would be doing right away. If we were approved, we would just do the structures right away. But the patio expansion was a thought process. And also, there was something else that they were looking at that we were just thinking about doing, but not something that we'd be doing right away.
So the patio is at the tent number 2. 1 second, Ms. Hanson.
Yes, sir.
And which is where the music is coming from, which
Correct.
if you have it opened air, literally music or noise can come.
I think it went out about 10 minutes ago, yeah.
There was 2 requests, one from the applicant's member and one from the other person that they can't hear her.
Sorry, we didn't mean to jump in there, but.
Oh, no, that's
one was
good.
hearing anyway. We'd have to repeat it anyway.
Yeah, well, luckily she only just started a couple seconds ago. We'll hold for a second recess off the record till Nate puts new batteries in.
Modern technology.
Ms. Bell, would you try to repeat what you said when we started our conversation?
Okay, so when we first started talking about doing the changes there at the villa, we would just like to change the tents and replace them with structures. The proposed patio expansion was a thought, not something we would be doing anytime in the near future. So I hope that kind of helps what you're asking, but it is an expansion from the dining tent
Okay.
or from the celebration tent.
Okay, and if I'm seeing correctly on the diagram that's on the screens right now. This would be an expansion or extension of the Pavilion 2, which is where the dance music is.
Correct.
Music, assuming that this is not an enclosed pavilion, there is no proposal, should this move forward in your quest, no proposal to put any outside speakers in that area.
From vendors coming in or ourselves, sir?
Either or, you have a requirement under the original decision about noise levels in that area.
Yes.
The tents, excuse me, the tents and or pavilions will, the tents have, since there's been no complaints that we know of, and the pavilions shall continue that noise level requirement.
Correct.
So that if this patio is an extension of pavilion, proposed Pavilion 2, there will be no speakers out there that would raise the noise level above and beyond what has been approved and you have complied with under the first decision.
Absolutely correct.
Okay.
Yes. Speakers would still be placed where they are right now within the structures built.
Right. And that is part of the reason why you and I had our little dissertation that was going on. So I appreciate your answer.
Yes, sir.
At one point, you wanted to say something, Mr. Hanson?
The issue I have with the patio, and this goes back to last year, my nephew got married, unfortunately not at your place, but another event center. Part of after the wedding, everybody was gathered outside in the patio. The noise level was tremendous compared to what would have been inside. You're going to use that as part of the event venue. I have issues with noise complaints. Number two, based on your testimony from the original case, 2373, and shame on me, but I assumed all the weddings were taking place in 10-1.
Ceremony, you mean?
Not ceremonies, not outside, as you just testified this evening. And I don't have so much of a problem with that. What I do have an issue with is with these events being outside. And again, apparently there's been no complaints. If you're putting speakers out there, as long as it's monitored by you folks, I don't see an issue with that. But now you want to add more outdoor space with this patio, which just could increase the noise that you're required to stay under.
I run a very tight ship, sir, and that patio area would not be allowed to be used after 10 o'clock PM. It would only be able to be used during the reception area for people that did not want to be inside the structure where the music is. They could just sit out on the patio area. It would be separate from the structure.
Okay. One of the other questions I had, one of the requirements under the original decision is you must have a parking attendant. Is there still a parking attendant there?
Absolutely. We have 3, sir.
Okay. Nate, I saw one of the people on Zoom had a question or a statement.
Kimberly Swartz had a comment about the noise complaints. Let me pull it back up. She stated she had called Hempfield Township Police due to the noise level on 5 occasions and didn't call on a Saturday when she might as well be a part of the wedding because of the noise.
Anything else?
And the
Not at
Saturday
this
one
time.
was this past Saturday, she said.
What'd she say?
The Saturday comment was for this past Saturday.
Okay. Is there any way that we can check with the police department to see if they have record of those noise complaints?
I can ask them about it. On the administrative side of the building, we have not received any, but we don't necessarily always talk.
Of course, on a weekend, there's nobody on the administrative side of the building.
Correct.
Anything else of this witness? Thank you.
you.
You want to continue? Is your
Sure.
person still on Zoom?
Jacques, are you available to speak or?
Yes, I am. Can you hear me okay?
Yes. Are you able to state your name, address, and occupation for the record?
Yes, this is Jacques Abreu, and I am the AGM here at the property. I'm at 543 Champ Boulevard. There at the Comfort Suites in Manheim, Lancaster. I do apologize for my voice. I am currently in quarantine with COVID, so I do apologize. And I was a part of the township meeting in the original agreement.
Don't apologize. Stay there. We appreciate it. Thanks.
Sure.
I just want to ask Jacques a couple questions because I know there were some statements about noise. And I would just say that, you know, this is already, again, a use that's been approved. So again, we're not changing any of the noise levels here. Is that correct, Jacques?
That is correct. All of the speakers would still have the exact same locations pointing towards 283. And just to clarify the noise complaint area, we do have meters that we take with apps. Each time there's an event, we do go up along the roads and we just justify to make sure that the sound is not going past our property lines.
Are you able, we discussed a little bit about the potential use of the pavilions during the off season. Are you able to elaborate a little bit as to why you might be looking for that?
You broke up there. Can you say that again?
Sorry, I was asking if you could give a little bit more information about why you're looking to use the pavilions during the off season.
Sure. So the particular off-season questioner that we brought that up in this statement is because fundamentally, if the pavilions are going to be up, it'd be nice to be able to use those as secondary meeting room spaces. Oftentimes the hotel may be double booked in a meeting room, and it'd be nice just to have another location to bring down a meeting. It would be on a rare occasion. Those would be very, very quiet events. Typically, it's like one speaker, maybe one, microphone. Usually there's no music in those particular events, small groups. And I know one of the gentlemen here with the township had indicated the cold weather. And I would tend to agree with that with certain dates. We've just noticed that there's been quite a few events that have been requesting to move into November dates. And that would be the risk, of course, of using an outdoor pavilion or outdoor setting in any capacity. But that would be something that we would like to be able to offer to our clients.
And are you able to state whether, it sounded like there wouldn't be any noise associated with the uses of the pavilions during the off season other than maybe a meeting occurring?
Oh, that's absolutely correct. The noise would be very little.
Okay. Those are all the questions I had for you because a lot of the other questions got answered previously. So I'm sure the board might have some questions.
Question, Mr. Hanson.
Part of the condition in the original hearing was when there are any events going on in the tents, the hotel could not have any events going on in their meeting rooms.
That is correct.
Are you still proposing that even if for meetings, if someone had to have a meeting after the wedding season was over to use this year round?
Yeah, so fundamentally, just to answer that question on the wedding portion, you are absolutely correct with that we never booked our meeting room space when an event is happening. That was a part of our original agreement. We've kept that since day one. When it comes to events that are outside of the wedding season, if we're talking between that November and April time, of course, there would be options there to utilize both spaces. If that is something that we could do, we would absolutely desire to do so, only because we're talking very limited people.
And
I don't believe your request addresses that.
well, I was just going to ask, I mean, Jacques, you were at the hearing. What was the discussion about the simultaneous booking of conference rooms and weddings due to the fact that there would be parking required for the wedding use and then parking for the hotel, that there may not be enough with the two happening concurrently?
Yeah, so the objective that we're mentioning now in regards to the off-season is that we do not anticipate those events at all. I shouldn't even call them events. They're more so gathering spaces. There are times where, for example, we have a coach that has a meetup group that come every Wednesday, and there's maybe 20, maybe 30 people, if that. There's not even usually that many people, maybe 15. So this would give an opportunity for us to utilize that secondary space for something of that nature.
Would they be guests of the hotel?
No, they're typically coming in from, a meeting group. Sometimes they are guests of the hotel. It just really depends on the day.
Would there be sufficient parking for that? Assuming that the weddings aren't happening at during that time?
Absolutely. We've never had a problem with parking. I know that was a big concern in the very original agreement that we had, but we've never had a problem with parking. Patty can attest to this as well. We do have a parking attendant on property, and Patty has actually been helping parking herself as well. So she comes and helps with that. So she can attest that the weddings have been, there's been no issues with parking at all at our property.
Thank you. For our Zoom person, I'm assuming that she can hear me. So what was her name? Kimberly?
Kimberly.
Yes, sir.
Kimberly, the music or the noise that you were hearing, was it from the ceremony or was it from the reception? Okay, for the reception. Thank you. The proposed walkways, and I understand why you want to build them to connect everything. With the proposed patio expansion, and I'll address this question to Nate. Since these are going to be permanent structures now, with all what they're adding and everything, this will require land development and water planning, correct?
We're working with the applicant on that on the side, that they need building permits for some things on the site, and they're working on the land development side.
Because I don't believe that under the original, they needed to do anything with water because they weren't considered permanent, correct?
I don't believe so. If I recall, we had talked about a stormwater plan for this project, and everything else would have been handled with the prior hotel land development plan.
But now that they're adding these permanent pavilions and this additional impervious surface, they are required to update their water plan, correct? Because
And that's what I was saying. We've been discussing with them potential stormwater plan.
does this square footage that they're going to make permanent now as impervious, does that come close to the lot coverage requirements? Or are they still way under?
For lot coverage, you're still way under.
And our engineer is here. I'm sure he could answer those questions for you. I don't want to interrupt your train of thought, but.
That's fine. Yeah, I mean, go ahead if you want to answer it.
Steve Gergley with Harbor Engineering. My business address is 41 South Main Street in Manheim, 17545. Yeah, we've had several conversations with township staff. The tent as proposed in the original plan, tent 1 in particular, was, I believe, considered a temporary structure and therefore did not require stormwater management. Tent number 2 or pavilion number 2 would be built over an existing impervious surface. That's a wash that would not be considered new impervious surface. But pavilion number 1 would be considered a new impervious surface. We've calculated the new impervious surface shown on this plan as compared to the land development plan. And I'm going to get into the weeds just a little bit. Nate, can you zoom out on the plan just a little bit, please? When we did the original.
Raise that or take it out.
Actually, I'll do this.
There you go.
Absolutely. So I don't get hunched over too badly. When we did the original stormwater management plan for the hotel, we accounted for a significant amount of additional impervious surface draining to detention basin number 1, which is just north of the parking lot, if that makes sense.
Use the pointer and look at that one. We've got it back to us.
This is detention basin number 1.
Okay, thank you.
We had accounted for future expansion in this area when we did the land development plan. We accounted for an additional 30,000 or 32,000 square feet of additional impervious surface. We did not include any additional impervious surface in this drainage area, which drains to the north. So if this is approved, we will come in with either a stormwater management plan or a waiver of land development plan to be worked out with the township board of supervisors and staff. We would do a stormwater management plan for the additional impervious surface in this drainage area, which is about 4,500 square feet. This area, if there's anything else in this area, it's covered under the previous stormwater management plan, if that helps.
Thank you.
And as far as lot coverage, the maximum permitted lot coverage in this district is 70%.
Right.
Currently, we're about 22%. With these additions, it would be around 23%. So we're well under that.
Okay. Next question, going back to Ms. Brewer. One of the conditions, condition number 13, and let me find it to make sure I read this correctly. If required by the township, applicant shall cause to be used within tent number 2, a house sound system with a programmable limiter, which is locked with a password, which controls a maximum volume and frequency distribution of the sound to protect the neighbors and ensure compliance with this decision. According to one of your neighbors, if you can see up there, it sounded like she was outside the arena or the outdoor concert venue at Hershey Park. She could hear the noise that loud from tent number 2 is where you hold your receptions, correct?
Yes, sir.
Do you use such a thing to maintain the noise level?
We do. And we also, at 9 o'clock at night, we actually drive over to the area. I personally do that myself. And I put my windows down and see if I can hear the music. That's during every wedding that we do. And I did do that on Saturday night, and I did not hear over in that area.
Okay, thank you.
Anything else? Back to you, sir.
Thank you. Steve, do you want to just, we've been referring to the plan and everything, but I figured it'd be good for Steve to just walk through sort of clarifying anything on the plan.
Okay, can you, Nate, blow that up again? So I don't need binoculars to see it.
Certainly, and I think it's been covered, but the pavilion number 1 would go in the location of tent number 1, which is again a temporary structure. Pavilion number 2 would go in the location of tent number 2, adjacent to the barn. And there's some additional impervious surfaces, walkways and patios as shown, and we've discussed the stormwater management, the site access, the parking, all that is unchanged from the previous application.
Thank you. Do you have any questions, any additional questions for Steve?
Nope.
I have one. And again, it's getting back to the proposed patio expansion. And again, with the applicant being at only 23%, I understand that that's not going to encroach on that. Do you know, or have you looked at whether with the construction of the patio, because what is under tent 2 now, proposed pavilion 2, was the former
It's a concrete surface. I think if that's
concrete
what you're
surface
asking.
that was originally there for the farm animals to come out on. I don't remember if the wall was around that yet or not. But is there anything that will be at the guess it's sort of northeast section of that patio that would also deflect any noise proposed?
Nothing's planned for that, no.
Okay. Nothing is planned as far as construction material. What about shrubbery? Pine trees, something like that at that end. Is there anything like that in the, suggested in the plan?
There's not, and to my knowledge, and I'm not a sound engineer or acoustician, I don't know that pine trees or any other shrubbery would have any significant effect on sound, quite honestly. Not enough to speak yes or no to that effect.
If you're not putting additional speakers out there, actually, shrubbery does help with controlling sound. But yeah, you're not a sound engineer, and I wouldn't necessarily expect you to know that. I just wondered whether any of that was in discussion, just looking at the plan. So I appreciate your response. Any other questions for this witness? Seeing none. I haven't asked you guys lately. I sort of forgot. But since both witnesses, if you have questions for them, Jason?
Yeah, I have a few, some for Steve, some for Patty, and maybe for Riley too. But so just first off, Patty is Patty with the I?
Yes, sir.
And what was your position again?
I am the director for Chestnut Hill Villa.
Director. Okay. And what was Jacques' position again?
He's the AGM,
The AG. and-
AGM, Assistant General Manager
Okay.
for Champ Group Inc.
Okay. So Patty, it will the after, if you get approval for the pavilions, you're agreeing that you will no longer have any tents set up on the property?
If we have both pavilions up, there would not be any tents, correct?
Okay.
Yeah, I would say, Mr. Hess, just a point of clarification. I think that and correct me if I'm wrong, Patty, but the pavilions won't be constructed at the same time, or they may not be.
Correct.
So you testified that when one pavilion's being constructed, it would be during the off season, but then let's say you construct one, during the off season of 2023, for the wedding season of 2023, you may have a pavilion and a tent in the other location still.
We may.
Okay. And so there's time limits in order to to get the permits and then to follow through with construction for after you get zoning approval. Is that something that you're able to meet, or are you gonna need extensions of time? Because if you think you're gonna need more time, it's probably best to ask the board now.
Explain your question to me, sir.
So I think, is it within 12 months that they need to get their permit?
Yeah, I'll double check, but I believe it's 12 months permit and project complete.
While they're looking, this is something we discussed, since I know you don't necessarily know the timing of everything, but the zoning ordinance will say, you have to get your permit. So they're just confirming that you'll be able to meet that for both pavilions, even though you're not constructing them at the same time. Do you have an estimate of when both pavilions may be constructed?
We would definitely build before our wedding season, so it would be early spring.
Of next year?
That I can't answer right now. It could be 2024.
Jacques, can you answer? I
Yeah,
see you're
thank
on
you.
here.
Yeah, so this is all a part about based upon cost and the ability to get supplies. So as we're all aware, supplies are a little bit more on the harder scale to get everything. So right now we're going through this process to first, stage one, make sure we're good to go to have these structures built. And then stage two is to make sure that they have the supplies And once we get that locked in, we'll be able to have a better time frame. But I think that's across the board for everybody.
Okay, so under section 270-9.1, D 13, okay. So after approval, you have 1 year to have a permit issued. And then you have an additional 1 year to complete the work that the approval was needed for. So is that something that you're able to do? Because, I mean, the board's had issues with people having to come back here and request extensions. And if you think that there's a chance that you might need additional time, it's probably best that you would ask that now, request that now.
I would actually refer that to Jacques. However, I do want to say that the structures that are being built are pre-made structures. So the design and them going up can be done fairly quickly.
But you're asking for them to be built in the off season. And according to you, your off season, if we grant what you request, would be from December 1st to March 31st. There's not a lot of footer construction that goes on in that time frame.
Yeah, we wouldn't book any weddings until the construction was completely done.
Jock, can you speak to the timing that Mr. Hess asked about? I mean, that would basically mean that both would have to be built, by 2024.
Yeah, I mean, the request for extension, I'm not familiar with the timeframes of that request. Excuse my voice. But what we would do is look at the cost analysis. If we're able to build them both at the same time, that is the hope or the gain. If we would need some additional time, if I'm hearing you correctly, that's where we would need to ask that now. Is that correct? Am I hearing that correctly?
You don't have to ask it now, but you're probably better off doing that because sometimes people forget and then they try to come back to the board after the time period's already expired.
I understand. Yeah. So I think that would be good for us to ask that now, if that's something that would make the most sense, only because of supply and demand. In a perfect world, if I could say, green light everything, and we got approval and we were able to start building right away after the wedding season, of course, we would do so. But unfortunately, we don't know when that supply is able to get to us and how much that's going to cost. All of that will determine that. So I think that is a good point to bring up, and I appreciate you bringing that up to request for that extension of time.
So I guess the next question would be if you think that's necessary, will you make a motion or will you make a request to amend the application to ask for that? And how much time would you need?
Yeah, so Jacques, we'll need to request here formally to amend our application and we need to give the board, how long they're extending the time for. So it's a year to get the permits and then another year to build it. So we'd be looking to you to kind of let us know how much time you think you need. Would it be, 2 years to
Yeah,
get the permits and another 2 to build? I mean,
Yeah, that would be the perfect world if we were able to get everything for that first pavilion up. And we would, let's walk this out. So it'd be first pavilion would go up in 2023, and then second pavilion would go up in 2024. If that would be possible to get all the supplies, that would be the time frame.
What was the last one?
2024. 23, 1 and 24.
Okay, thanks.
Now, and like I said, though, in the perfect world, we would put them both up if supplies are all available. we'd put them both up right away in 2023. If they're not available, then we would have to go for that extension. And I do want to bring up a point because I do see Kimberly's perspective here that she mentioned on Skype. That she says, I don't care what they do, but I don't want to hear it. I do want to mention that we have been working together with our neighbors, and we do want to make sure that all the activities that we do are going to be benefiting our neighbors. And so one of the points I do want to bring up is that was one of the things we talked about was putting in those glass, those sections that can go in and out. Is that our hope would be that that would also reduce sound as well.
Yes, I should probably request that the applicant amend its application to request an extension of time under section 270-9.1.13 to allow construction of both pavilions by 2024. I guess applicate, don't know how to word it, maybe application for building permits for the second pavilion to occur in 2023.
So, I mean, are you thinking that you need an extension of time to get the permits or extension of time to construct after the permits, or both? I mean, I'm not suggesting the board would, it's up to the board, but I'm just wanting to know what you're requesting.
Jacques, I don't know if you're there. Do you think you'd be able to apply for the building permits within a year and then just the construction would be completed, you know?
Correct.
Okay. So then it would just be a request to complete construction of the second pavilion by 2024, by the end of the year of 2024.
So the way the ordinance is written, I believe, it's 1 year after the permit, correct?
Correct.
So if you were to get the permit, say August, you would have till August of 23 to complete your construction. So if you couldn't complete it by August 23, we would need to know exactly how much additional time you're requesting. The normal is usually 1 year.
Yeah, that's what Mr. Gergley just said. He'd feel comfortable with us requesting an extension for an additional year to complete construction.
So you don't, but just to be aware, you don't need anything for the permits. You're more concerned about construction.
Yes, that's my understanding.
Okay.
Jason, help me out on this section.
Okay, so I guess the request is to amend the application to request an extension under section 270 -9.1D13. Is that right?
What'd you say? E, D, D.
Oh, D13A.
D13A.
D as in dog. 13A to request or for an additional year to complete construction after obtaining a permit. Is that right?
That's correct.
That's assuming 1 permit, but 2 pavilions.
Okay, gentlemen. We have a request by the applicant to extend or to amend the application for section 270-9.1D.13A to allow the applicant 2 years from the applicant picking up the permit to construct pavilion number 2, which is replacing tent number 2.
Wouldn't it be better to word that to complete all construction as requested?
No, well, from my opinion, no, because they will have to complete
At least one.
the one within the first year.
Right.
And then they got the second because they have said they want to do one pavilion, proposed pavilion 1 in 23, which would be the end of 22 into 23. And then the following season for, 23, 24. And that way they don't sit on construction till the very end, in my opinion. Okay,
I'm good with that.
okay. That's a proposal. Do I have a motion?
So moved.
Moved by Mr. Luce. Do I have a second?
Second.
Second by Mr. Hanson. Any discussion, gentlemen? Seeing none, Mr. Hanson,
In favor.
Mr. Luce,
In favor.
Mr. Kyle,
In favor.
Mr. Bingham,
In favor.
and I also vote in favor. So your application has been amended to stipulate that the applicant has a 1-year extension for the construction and completion of pavilion number 2. Understood? Okay. Jason, you still have the floor.
Okay, one question maybe for you, Riley. So for an application to modify conditions, the legal standard is you either need to show grounds for a traditional variance or that there are changed circumstances which render the condition inappropriate. So are you suggesting that it's based on changed circumstances?
Yes, so I believe Patty testified that, the change in circumstances really were the external factors of COVID-19 and demands in the wedding industry, really rendering these conditions to just limit it to tents, kind of moot in light of kind of the current demands and what we're seeing in the industry.
Right, I think that's all I have, Mr. Chairman.
Excuse me.
Those are the questions I had.
Oh, Nate, do you have any questions of the witnesses?
I do not know.
Anyone in the audience have any questions for the witnesses? We'll hold on the comments then in the audience and then on Zoom, Dr. Zarco.
Richard Zarco, 2512 Shank Road. I'll use the microphone so everyone can hear me even on Zoom. I've been into a number of big tent weddings where the dinner is in one tent, the dance floors on the tent, the band or D-Days in the same huge tent. The sides are always down. You intimated or said that you usually roll the sides up of these tents during the weddings that you've had?
It's actually.
You got to share the microphone with the doctor.
It's the preference of our couple. We're on grounds the whole night. So if the couple says, open the sides up, we'll open them. If they ask them to close them, they'll close them. It's usually due to it being cold or hot.
I mean, I would imagine it's a lot harder to control the sound, the noise leaving the area. There's you stated, somebody asked whether you had that a limiter that was mentioned in condition number 13 of the original special exemption, and you said you do have it. My recollection was that Mr. Abreu balked at that and refused to have it. Now, what is defined or being talked about in condition number 3 is a device that has a password and or a key, and all the amplified music from the guitars, the drums goes into this device, and then the sound limit is set and then goes from this device into speakers that are permanently there. They don't come from the band. So the band is not using any of their own amplifiers. So are you saying that you already possess this type of device?
I'm going to let Jacques answer that question because he has the better structure and understands all that electronic equipment way better than me.
So just to clarify, we do not have the limiter on property. Dr. Zarco, nice to see you again. Patty, what she was indicating, she might have been thinking you were talking about the device that's on the phone. That's just the meter that just indicates what is on, each property line. That's what I believe she was answering that question to. But the indicator that's indicated on number 13 is not something that is required unless the township requires it for a property, which is not the case.
Thank you. Just one more quick question. Would I then sit down for making a statement later, or do you just want
You'll get to the statement later.
later? Okay. There's, as Mr. Herr picked up, there seems to be like loose language or loopholes that, from a noise standpoint, I would be concerned about. At one point in your on this application, the new application, it says we may build up to 2 pavilions. And then in some other areas, it indicates that for where tent 2 or pavilion 2 would be located, it's like I'll read from the page 4, tent 2 / pavilion 2, and or, I think there's several locations on this document where it's and or the outdoor patio area in that location will be used for receptions and dancing. I think, that implies that that's a loophole that you might have dancing on the patio. And in one area, it looks like, if the tent isn't up in area 2, that you may have the music there anyway. So I am concerned about at least the language used in various places here. Do you wish to state on the record that you will never have dancing and music other than inside a pavilion or inside a tent?
Absolutely, sir. All the DJs, all the music, Bluetooth speakers, everything like that, the electric for it is in both of the tents, 1 and 2. They wouldn't even have electric to put a speaker out there at the patio area. If they utilized a speaker, it would probably be a personal, maybe a Bluetooth speaker or something like that, but nothing from our end or the DJ end outside of the tent areas.
That's all my question. And later I'd like to make a statement.
Yes.
I have a question.
Well, not for him.
He does, though.
Well, that's, can't wait for this. Okay, statement.
I have a
Yeah.
question for Mr.
Okay, and is there any questions on Zoom? I don't see any questions. Okay,
Ms. Brewer, just out of curiosity, how many events have you had at the venue since you got approval for it?
I've only started as venue director in 2019. We haven't had a complete full booked year yet, and we only do 1 wedding a weekend. So I wouldn't know without having my paperwork exactly as many weddings as we've done, but since I came on with them, I've been present at every wedding.
So the original approval was 2017. You came
Yes.
on 2019.
Yes, sir.
What your AGM been with the hotel this whole time?
Yes,
I
yeah,
would have
he's
been.
been with them the whole time.
Mr. Brew, how many events have it been taking place since the original approval?
I can pull up records for you if you'd like me to do so. Would you like me to give more of a rough estimate, or would you like totals?
If you could just submit that information to the township.
Oh, sure. Yeah, I can do that.
Anything else? Anything else, gentlemen? Anything else you want to add at this point?
I would just ask Patty, I mean, to reiterate, have you complied with all of the conditions of the decision up to this point?
Yes, sir.
Thank you.
Thank you. Anything else you want to add before I ask for comments from the others, anybody pro or con?
Sorry, I would just conclude that, again, as the testimony indicates, there's not a change in the use or a change in the noise levels. It's just merely changing the length of the wedding season, ancillary uses that may be conducted off-season, and the permanency of where the use is conducted. Other than that, all of the testimony from the 2017 hearing remains the same. So while I understand that there may be comments and concerns and questions about noise, because the use isn't changing, and the zoning officer testified that there haven't been any complaints to him. We feel that we'd be willing to hear those, but they're not really something that the board should consider in granting the modifications.
Before we go on, can I ask the Gerkley a question?
1 second. Yeah, go ahead, Mr. Lewis.
Mr. Gerkley, just a quick question for you. With the pavilions on there, are there going to be installed ventilation in them? I mean, there's talks about putting the windows and everything and walls, temporary things on there, ventilation wise.
I can't answer that. And I don't know if Jacques or Patty can answer that at this time either, since they haven't been fully designed.
Okay. That's all I have.
Yeah. Thank you. Anything else? Okay. Well, Mark? Mr.
Dave,
Hanson?
was Kimberly a part of the case?
Yes.
Does she understand what's involved, that she get a copy of the written decision?
I mean, Elam explained that at the beginning. I don't know if she was on the Zoom at that time.
I would just clarify that is this Kimberly Swartz? Is that who? Because it says in the decision that she did not enter her appearance or become a party. So I don't know if.
But she did in this case.
She did.
I mean, this is a separate case, so she can be a party to this one.
Yeah, I didn't know if the question was about the prior hearing.
Maybe we should ask Kimberly if she understands what it means to be a party, and that you have the right to ask questions at this time of the applicant if you wish.
You have a question?
Yeah. Ms. Swartz, do you have any questions? Please type in yes or no. Yes. Understand your question. Actually, in 13,
It does require.
the township, it says if the township required, we'd have to find out if the township required that limiter. Who is the zoning officer? The zoning officer is Nate Sturgis. You can call the township office and ask for Nate. He'll answer your questions that you may have.
We can condition what she's asking for.
We can potentially change that, but well, there's a potential that we could change the condition, but if you're asking the township per se, that would be the Board of Supervisors, not this board. The previous condition in 13 was that the township request, that is the Board of Supervisors. Again, you can talk with Nate. Yes. Yeah, and I just got new glasses. Yes.
And I'm sending her my contact information.
Okay. Nate is sending you his contact information. So you will receive that soon. Is there anything else at this time, Ms. Swartz? Okay, thank you. Appreciate that. With that now, comments, Dr. Zarko?
I have a packet of information for the board and a copy for counsel for the applicant. I didn't think that there are 4 items in here. I didn't think having people read it during the comment period would be appropriate. It's pretty complex. Complicated. There are 4 things in the packet. Number 1 is a model noise ordinance for the state of New Jersey. And this is, New Jersey has its noise ordinance, and the model is given out to all the local governments, and they are supposed to base their noise ordinances using that model. They can be more stringent in terms of curfews and things like that and noise levels than the state, but they can't really deviate from that. There's the website for New Jersey noise control divisions and all the links, and I provided the web address. There's a little comment about what is the difference between noise and nuisance, and Mr. Norm Dottie, who was an expert witness in noise, who I used for the heliport hearings back in 2006 and also in 2017, his website, in case the board or somebody, an official from the township wishes to contact him.
So just Dr. Sarko, just so you know, this board has no jurisdiction over the noise ordinance. So you gave it to Nate, which is good, and he can give it to the Board of Supervisors. All we can do is stipulate that the applicant or any applicant stays in compliance with the adopted noise ordinance. Just
okay. Well, I'm not familiar with the politics of how the township works, but
well, that's
you know,
not how the township works. That's how the state tells us to work.
But it might be beneficial for the board members to read that before passing it on. And it's apropos. I'm not here to protest the pavilions or to prevent them from extending their wedding season. That's not my goal. My concern in 2017 was for noise in the neighborhood. And that's still my sole concern at this point. And it's very apropos. Saturday's paper had an article about club owners promised to appeal ruling of noise violations from downtown Lancaster. I have not had the time to try and review Lancaster City, the noise ordinance, to see if it's like ours or not. But, you know, my goal is to try and get the township to create a condition where we don't have to argue about noises. And if there is a complaint about noises, that the people making the noise can't appeal it or can't, you know, deny that they're obligated to follow whatever the township thinks they ought to be doing. I just, again, just want to make the point that the extended period that they're asking for, April 1st to November 30th, is eight months long. It's 2/3 of the entire year and includes every single day with comfortable weather to be outside lounging in your yard, sitting on your porch, or enjoying your backyard pool. So there needs to be in place some conditions that are defendable for noise provisions to protect the neighborhood. Testimony by my expert, Mr. Norm Dottie, who's a certified expert witness concerning noise, vibration, and sound in 2017, gave several examples of how noise can be controlled in the music tent number 2. He also either testified or told me privately that the existing township noise ordinance in 2017 would not be enforceable in court. It never mentioned any decibel levels at all, which in his opinion is required to have something that's defensible. And by the way, Mr. Norm Dottie essentially was on the committee and may have completely written the noise ordinance for New Jersey, the state of New Jersey. He's very, very well known and very, very knowledgeable. I thought Ms. Schwartz would be able to testify by audio, by voice. She did testify at the Panettone trucking warehouse hearing and said that she had called the township police several years ago 5 times without having the police respond. And after a few months after that, she and I came to a supervisor's meeting and complained about not getting any police response to a noise complaint. And Chief Skiles, sitting at the front desk, said it is the police department's policy not to respond to a noise complaint if only a single individual calls complaining about the noise. And so our neighborhood along Schenck Road and the next group of houses that would hear the noise from the wedding venue were really widely separated, except for a few houses along Spooky Nook Road. And before the board sat down, I asked Mr. Sturgis whether he could look at Google Earth and give me an idea on how far, using what's called a Google Earth ruler, which I don't know how to use myself, approximately how far my house is and Kimberly Schwartz's house is from the wedding venue. And I believe it was 2,000 feet from my house and 2,200 feet from Ms. Schwartz. She can hear things that I do not hear, and I can't explain it. I am not a sound engineer, and have not walked that distance to find a physical reason acoustically why the noise seems to be affecting her to a much greater extent than at my backyard. I personally have not heard a lot of music noise. Once last year, I heard a live singer singing for a minute or two. And on another day, about a year ago, I heard a bass player, that thumping bass rhythm, similar to that heard from a hot rod car when it drives by with its windows down playing loud music. This past Saturday, 2 days ago, I heard 2 amplified announcements between 7 p.m. and 8:15 p.m. Although I could not understand the words. Again, my backyard should be 2,000 feet away from tent number 2. And something like that would not cause me to make a police noise report. But I must bring to your attention that this sound clearly falls into the category labeled as plainly audible. That's a term in quotations. It is defined, the term plainly audible is defined in the New Jersey Model Noise Ordinance. And I'll read just that definition for plainly audible to you from the definition sections of that document. Plainly audible means any sound that can be detected by a noise compliance officer or noise compliance inspector Use, an inspector could be anybody, you know, because secretary sent out from the township to be designated. They have no training. They're out to hear what the noise sounds like. Using his or her unaided hearing faculties of normal acuity. As an example, if the sound source under investigation is a portable or vehicular sound amplification or reproduction device, the detection of the rhythmic bass component of the music is sufficient to verify plainly audible sound. The NCO or NCI need not determine the title, specific words, or the artist performing the song. Or performing the song. That's the end of the definition. So by that definition, me hearing a bass thumping or even that announcement would be considered plainly audible by the definition used in there. And the township could also, if the noise ordinance is not amended, can put conditions based upon plainly audible in your ruling. So, and also maybe you can put the condition that the police policy change so that they have to respond to a single noise individual complaint rather than having two people call.
I'm not sure the Board of Supervisors would like us to be telling them what to do. Again, that would be something you would have to request of the Board of Supervisors. This board does not have that jurisdiction.
Let me ask you this, Dr. Zarko. One of the conditions that was required in 2017 was, if required by the township, applicant shall cause to be used within intent number 2, a house sound system with a programmable limiter. And this question is also to you, Mrs. Schwartz. And I can't speak for the whole board, but if we were to grant this, if the board was to grant their request for modifications, if we put a condition in there requiring that in both tents, would that help you folks out?
Oh, absolutely, because the noise decibel level is controlled by this device. And so if they set it at, say, 100 decibels, then, and there's still noise complaints, then you ratchet the dial down. And so you reach a level where, you know, nobody complains anymore, but that's the absolute control. Mr. Doughty had recommended a couple different recommendations in 2017, one of which was to have ceiling mounted speakers that directed the noise downward instead of noise speakers that directed the music sideways, or speakers located at ground level. I talked to Mr. Doughty yesterday on the phone, and I said, what would a high quality master controller cost? And he said, a very high quality master controller is sold by several companies. One reliable company is called DBX, as in dog, boy, xylophone, and it costs $1,000 or less. And then that controller, the applicant would buy speakers that attach to that, so that each band or venue coming in would not have their own speakers or their own amplifiers. All their sound would go through that mixer or limiter and then come out through the speakers that the wedding venue would own, and would be permanently then installed in their pavilion. And so I would imagine the total cost for a system like that is $2,000 or less, which is probably less than the cost of one of their pavilions, or less than the cost of what their legal counsel will charge them during the times of these hearings. And so if people can convince the supervisors to redo their noise ordinance so it actually has some teeth and can be enforced, I would be willing to underwrite the cost of 2 professional grade sound meters recommended by the township's noise consultant. including the calibrator devices so that they're accurately calibrated. Again, I asked Mr. Doughty, what would that cost? He estimated that each meter would cost about $1,000. So I'd be willing to pay $2,000 or $2,500 to support the township to give them the impetus to get a better noise ordinance. I encourage the township to consult Mr. Doughty or another qualified noise expert. I already mentioned that he was instrumental in writing the New Jersey model, and I provided his website in my packet to you guys. I think it's important that the township, noise is a complex subject. And I'll quote or probably paraphrase Donald Rumsfeld, not that I have any great love for Donald Rumsfeld, but he said, you know, there are things there are things that you don't know, and there are things that you don't even realize you don't know, the so-called unknown unknowns that you should probably be worrying about. And noise control is like that. Yesterday, when speaking with Mr. Doughty, I mentioned my concern about the backup beeping from 10 trucks per hour at potential Panettone truck warehouse along Route 283 and Spooky Nook Road. And he said to me, he educated to me, he said, most 18-wheeler cabs don't have backup beepers, warning beepers. Some do, but the majority do not. He said, on the other hand, all those jockey cabs that move the trailers after the cab leaves and drops off its trailers, they do have those beepers. But that problem can be easily solved. In his email to me, he sent me 2 MP3 files of backup beeper sounds. And Mr. Sturgis has seen this and put it on his computer, but I'll leave this flash drive with the township. And so there are 2 MP3 audio files. One is 3 seconds long, one is 2 seconds long. That's the only thing on this flash drive, those 2 files. And the difference between the standard backup beeper and what's called a adaptive multi-spectrum backup warning beeper is like night and day. It will get rid of any sound complaint whatsoever. He was involved in a case involving either Rutgers or Princeton University, where they were installing ground heat pumps all over the place, and construction was all over the place. Professors and students all complained about the construction beeping, backing up. And he made that suggestion. The contractor installed them. And 2 weeks later, the head of the company called him, and this was a nationwide company. He said, that was such a wonderful idea. It works so great. I'm going to install the, what do we call that? The adaptive beeper to all his trucks nationwide. And so the point I'm trying to make is, for sound, there are some things you worry about that may have a simple solution, and you may argue about them and have problems with applicants or building permits or whatever. And there are other things that you probably have no idea and should know about. And for that, you should get a sound expert involved. And so I encourage this board to make the right decision, but certainly one thing that can absolutely solve the problem is that limiter.
Just to respond to everything, and I appreciate taking the time. A lot of what you have requested of this board, we have no jurisdiction over. The ordinance that the sound ordinance, noise ordinance, zoning hearing boards have no jurisdiction to change that. That has to go to the Board of Supervisors. If they would change the ordinance and we apply it, we can apply the ordinance as we attempted to do in the previous case. But we cannot change anything in that. We just don't have the jurisdiction. The legislature and governor have not given us that power, and the appellate courts, have only given us some limited power through their decisions. The information you have given, Nate has, he can convey it to the manager and whatever the administration does. We will look at this and take into consideration about the noise, but again, we can only apply in the decision limitations which would be within the ordinance, as we attempted in the past, and maybe that needs to be modified or not. I'm not sure, just talking to you. So with that, it's not that I'm saying I didn't appreciate what you have said. It's just that we have limited authority in what we can do.
Well, I'm just trying to be helpful. I would love
And I
to be part
understand
of the solution rather than
and-
part of the problem. So I'll leave this with Mr. Sturgis and he could pass it around just for your own edification on the difference in what the sounds are like.
That's true. And I appreciate you coming in and voicing it. The whole concept is the comments are added to the record. It highlights your concern, which is not what is there. It's just that your life you do not want to be disrupted by somebody else getting, relief from the township. And I understand and I appreciate your comments, but you can't leave. Any questions for Mr. or Dr. Sarko? He answered any I had. Anything? Jason?
None.
Nate? Anybody on Zoom? Is it me? It is. It's just me. Yeah, okay. I tell you, they're fuzzy. I just got new glasses. Okay,
It's not easy to read, but it's.
thanks. I'm glad somebody stuck up for me. Any questions of the witness?
Oh, none.
Then I'm wearing trifocals, so.
Thank you. There's no questions.
Before you close testimony.
Yeah.
I'd like to ask Ms. Brewer a couple questions.
Okay. Is there anyone else who wants to present comments, pro and or con? Last chance. Seeing none. Mr. Hanson.
Ms. Brewer, the music that's provided, does the hotel require only DJs or do they allow bands also at these wedding events?
We would allow bands. We don't get bands, but we do allow them.
Okay. Thank you.
Is that it? Any other questions? Anything else? Seeing none, with that, I will conclude testimony in case number 2449. We'll take administrative notice and add to the record case number 2373. We will also add into the record zoning hearing board's exhibit 1, the application in case number 2373 and the zoning hearing board's excuse me, exhibit excuse me, number 2, the decision from case number 2373. The application had been previously amended to put the new case number in, and also, gentlemen, remember, it's been amended to ask for the extension of time.
Mr. Chairman,
With that,
in case, sorry.
I'll finish first. I'm just making sure I got everything here. You're jumping the gun on me. With that, we will conclude testimony and I will listen to a motion in case number 2449 at this time.
Mr. Chairman, in case number 2449, the request of the Champ Group Incorporated for property located 543 Champ Boulevard, Manheim, Pennsylvania, 17545, requesting modifications to conditions in case number 2373. I make a motion to take the allowable 45 days to make a decision.
Okay, a motion by Mr. Hanson in case number 2449 The property at 543 Champ Boulevard, Manheim, PA 17545. That the board take its allowable 45 days from the conclusion of testimony to render a decision. Do I have a second?
Second.
Second by Mr. Kyle. Any discussion? Seeing none. Mr. Hanson,
In favor.
Mr. Luce,
In favor.
Mr. Kyle,
Favor.
Mr. Bingham,
In favor.
and I also vote in favor. This board will render a decision within 45 days on case number 2449. We'll also request of the applicant that the request by Mr. Hanson about the number of wedding ceremonies that have taken place at the facility or the site be submitted to Nate for the township.
I'd also like the township to check with the police department.
Yeah, and I was getting that. Man, you're in a hurry.
He is.
I tell you.
I'm gonna
And
be like
Nate-
Mr. Beard, remember him?
Oh, God, yeah. Well, you still got an hour and 14 minutes. Would you also, Nate, check with the police department about any calls on this property?
Yes, sir.
Okay, with that, ladies and gentlemen, I appreciate the time everyone took. Nate, is there any additional cases, any thing we need to do?
No, there's not.
Next meeting?
Deadline is the 27th.
Okay, and we'll have this one
Sure.
as a decision. Yeah, isn't sure.
And don't say you're, because you, like, the last 3 months now you've lied, so just.
With that, this meeting stands adjourned. Thank you, everyone.
Thank you.
Yeah, I gotta
You
sign.
got some signatures.
You know, you could start passing these out, like, beginning of the meetings, we can have them all signed by then.
Cheryl, do you need these? Or are you gonna?